Hello, my name is Ryan Young. I'm an attorney in Richmond, Virginia. I wanted to talk to you today about the difference between a testamentary trust and an inter vivos trust. As an interesting aside, I have a blog at rcyounglaw.com, and for whatever reason, this is one of the most popular topics that I've written on. It kind of surprised me. So I thought that I would give this short tutorial today. First things first, how is a trust created? The Virginia Code, in that code section, lays out the methods of creating a trust. As you can see, there are multiple different ways to create a trust, but we're going to focus on the two ways during the settler's lifetime, which would be an inter vivos trust, or by will, which would be a testamentary trust. If you're reading this or watching this video a year from now or 2 years from now, you're going to want to do a quick web search of methods for creating trust Virginia to make sure that you have the correct code section. I don't think that these two are going to go away, but you might just want to see what the language is a couple of years down the road. Definitions that are important for this tutorial are: settler is the person who creates a trust. Trustee is the person who manages the trust assets. They are the custodian of the trust assets. They hold the trust assets. If this is an inter vivos trust, the settler and the trustee will oftentimes be the same person. If it's a testamentary trust, the person who's created the trust has passed away, so they would want to name a third party as the trustee. In almost every situation, you would want to think about a primary trustee and then successor trustees in case the primary person cannot serve. Beneficiaries are those who may benefit from the trust. An important thing to note is that beneficiaries must be clearly defined or ascertainable. They must be in a class of persons, my children. You cannot be overly broad or vague with beneficiaries, or else the trust could potentially fail. Beneficiary could be a charity, just as a thought, but you must be able to clearly define who that person is or charity. A testator. Testator is a person executing a last will and testament. An inter vivos trust. Inter vivos is Latin and it means between the living. If I'm mispronouncing that and there's any Latin scholars out there, I apologize. I never took Latin in school. As the code sets out, it's during the settler's lifetime. This is oftentimes referred to as well as a living trust. It's the same exact thing. There are different ways of creating a trust, but if you went to an attorney or came to my office tomorrow and said, I would like to create a trust, I would draft a declaration of trust. This lays out the terms of the trust. It's kind of a governing document for the trust. It lays out the various steps that the trustee must take. It's not enough to just simply draft a declaration of trust. In order for the trust to be valid, property must also be delivered to the trustee. It could be real estate, cash, checking account, 401k, IRA. Something of value must be delivered to the trustee in order for the trust to be valid. As we spoke about earlier, there must be clearly defined beneficiaries. In the inter vivos trust, this is getting a little bit more complicated, but it could be either revocable or irrevocable. For the majority of persons, they are going to want a revocable inter vivos trust. One of the main benefits of an inter vivos trust that you might have heard about is it avoids probate. There's less judicial oversight than a will. If you were to transfer all of your property into an inter vivos trust, you could largely avoid probate. There's probably going to be, as part of your estate plan, you will probably have what's known as a pour-over will. This is in addition to the inter vivos trust. Basically says if there's anything left over, something that I missed, household items, they will all be sold and all that property will pour over into the inter vivos trust. So I would actually name the Ryan C. Young Living Trust as the beneficiary of this pour over will. The benefit is, though, that if you do the proper planning in advance, it makes that final step much easier. A testamentary trust is a type of trust that's drafted into the last will and testament. The most common usage of this that I see is if I have minor children, I would say, in the event if a child is entitled to a share under this will is below the age of, for example, 21 years, that child's share shall be retained in trust. Obviously, you don't want to hand a 10-year-old $100,000. So that's something that's where this goes into the trust for the most, into a last will and testament. This is the most common example. Obviously, if the person's over the age, then you wouldn't have to worry about it so much. There are other examples of a testamentary trust, and they're the same for inter vivos trust, special needs trust, or a spendthrift trust. For example, if you have a child who's disabled, or a beneficiary who's disabled, or I've had clients who have a beneficiary who might have a drug or alcohol addiction, or they have problems maintaining their finances. So that is a way that you can draft. And the same rules apply for testamentary as an inter vivos trust. There's very different ways that you could think about this and problems that might arise. So what happens is, under the testamentary trust, as you have this last will and testament, and property is then delivered to the trustee at the time of death. So the trust becomes valid upon your death. And this would not avoid probate, so the whole entire will and estate would probably have to go through the probate process, it can be lengthy at times. The next question is, I don't have a clear answer for you without speaking to you directly, but which is best for me? The answer largely depends on a review of your financial situation and unique family situation. As we talked about, do you have minor children? Are there family members that you're concerned about? Are there specific family members that or persons that you do not want under any situation inheriting under your estate? Those are different things that we need to talk about and have a confidential discussion regarding your family composition and your specific property that you own. At the time of this video, the majority of persons are not going to have to worry about estate tax, federal estate tax. Virginia has no estate tax. If you do have questions about that, you should speak with an attorney. But most estate planning for me deals with making the life as easy as possible for your loved ones when you pass away. And so a personalized estate plan should seek to make the transition as smooth as possible. As a general rule, and this is something I skipped over, creation of a trust typically costs more on the front end, so you have more legal fees to create the trust than a last will and testament. However, in many situations, a trust can be easier and cheaper to carry out after death. So that's something to think about. The more property that you have and the more complex your estate is, the more that I'm probably going to push a trust on you. So, you need to sit down with an attorney and discuss your specific needs. Once again, every plan and situation is unique. Your plan should consider your values, your belief system, your finances, and your family. I want to know what's most important to you, and that's something you need to discuss with your attorney drafting your estate plan. And sit down and make a list of what type of legacy you wish to leave behind, notes that you have, and that will make your meeting with an attorney as beneficial as possible. I look forward to hearing from you. I wish you all the best. Take care.